Hello, I'm Shashank Mishra representing as a host with the renowned senior advocate of Supreme Court of India, Subodh Markandeji. The motive of the channel Law and Life is to share the experience of senior counsel on various legal issues that are happening in India, political history, and explaining various statutes. In this lecture, we will be dealing with the judgment of Gyanwapi Mosque. In episode number 13, this channel gave a detailed account of suit 693 of 2021 filed by Rakhi Singh and four Hindu ladies for declaration and injunction restraining the defendant from interfering with their worship, Sri Nagar Gauri, Sri Ganesh, Sri Hanuman, and Nandi, and other visible and invisible deities throughout the year instead of just 1 year. In that suit, the four defendants Anjuman-e-Intijamiya Masjid had approached the Supreme Court against the order of High Court of Judicature at Allahabad, dismissing the judgment to survey as directed by the trial court. It has also filed an application for rejection of plaint under Order 7, Rule 11, Clause 4 of the Code of Civil Procedure Code 1908. Having regard to the sensitivity of the matter, the Supreme Court of India, by its order dated 20 May 2022, transferred the said suit from the Civil Judgment Senior Division to the District Judge Varanasi with a specific direction to dispose the application under Order 7, Rule 11 CPC, filed by the defendant number 4, Anjuman-e-Intijamiya Masjid, Varanasi. So, what order has been passed by the DJ Varanasi? Can you explain further, sir?
So the fourth defendant, that is the Intizamiya, Anjuman Intizamiya Masjid, in its application under Order 7, Rule 11, uh, Sub-Rule 4 of the Code of Civil Procedure, had urged that that the suit filed by Mrs. Rakhi Singh and others was barred by three laws, that is, Places of Worship Special Provisions Act 1991, then the Waqf Act 1995, and the UP Shri Kashinath Vishwanath Temple Act 1983. So let us recall the Supreme Court, by its order dated 20th of May 2022, had directed the district judge to give adequate opportunity to all the parties for hearing before passing the order. Uh, the district judge therefore heard this application under Order 7 Rule 11(4) at length, and by his order dated 12/9/2022 dismissed the said application. The judgment runs into 26 pages. It narrates in ample detail the contents of the plaint, the written statement, and the application under Order 7, Rule 11, filed by the fourth defendant. Then he poses the questions which arise for consideration. Then there are as many as 35 cases cited by the parties. But in the result, he dismissed the application under Order 7, Rule 11.
Sir, can you tell what has the district judge held?
So the district judge firstly ascertained as to what has to be taken into account while disposing of an application under Order 7, Rule 11. That's necessary because he must know uh, the, the parameters or framework within which he has to operate. Then he separately tested the bar of jurisdiction based on these three laws, namely the Places of Worship Special Provisions Act 1991, the Waqf Act 1995, and the UP Shri Kashinath Vishwanath Temple Act. Actually, usually what happens is that bar is invoked in respect of one particular law, but here the bar was invoked in respect of three laws. The Intizamiya committee said that it is barred by as many as three laws, so he had to examine it in great detail. Now, therefore, let's see what he has held. As regards the scope of power of the court under Order 7, Rule 11, the district judge, after considering as many as 14 cases cited at the bar, held that at the stage of exercising power under Orders 7 Rule 11, the court has to consider only the averments made in the plaint and not the defendant's case. That's what the Rule 11 itself says, that he has to look at the plaint. Now, he separately considered, the bar in respect of those three laws. So, as regards the bar alleged to have been created by the Places of Worship Special Provisions Act, the district judge held, he first of all read sections 3 and 4 of that act, and in that light looked at the averments and prayers, that is, reliefs claimed in the suit. And in that regard, he also considered section 9 of this Code of Civil Procedure, which says that civil courts, subject to the provisions of the court, have jurisdiction to try all the suits of civil nature except the suits of which the cognizance is either expressly or impliedly barred. So this is the framework within he has to operate. So district judge therefore found that the plaintiffs are claiming that even before and after 15th of August 1947, which is the cutoff date for that act, till 1993, they were actually allowed to have darshan and offer puja, archana, and bhog daily to the deities which exist within the property in question at the back of Gyanwapi Mosque in the north and east corner. But the district administration restricted their entry only for one day, that is, fourth day of Chaitra Vasantik Navratra. So that is their grievance. That previously they were allowed to come to the premises and offer, archana, puja, uh, arti, bhog every day. Now in 1993, the district administration restricted their entry. So that was the that was the cause of action. Therefore, the plaintiff have the right. Therefore, what the district judge has held is that these are being the pleas in the plaint, the plaintiffs have a right to prove their plaint averments by cogent evidence. This proposition is supported by a category of decisions cited at the bar. So the plaintiffs have not sought any declaration of injunction over the property or land or plot bearing Khasra number 9130, nor are they seeking to convert the place of worship from a mosque to the temple. So this is very clear. They are only demanding right to worship, which already they had and they had exercised uh, from even before 15th of August and after 15th of August till 1993, and which has been curtailed by the state of Uttar Pradesh. Therefore, the district judge came to the conclusion that the Places of Worship Special Provisions Act 1991 does not operate as a bar on the suit of the plaintiffs. So now coming to the Works Act 1995, the district judge noticed that the relevant section is 85, which creates a bar to the civil court's jurisdiction. But wide as it may be, there are limitations. And therefore, he noticed the nature of this suit, namely to allow the plaintiffs to worship the deities existing on the property, and held that such relief is not covered by the sections which are envisaged under the bar created by Section 85 of the Works Act. What are these sections? There are many, but still they are limited. They are sections 33, 35, 47, 48, 51, 54, 61, 64, 67, 72, and 73. And after seeing them, the district judge came to the conclusion that the plaintiff's suit is not barred under those sections. Now he took up the third law, that is to say, the UP Shri Kashinath Vishwanath Temple Act, 1983. So the district judge, on examination of the provisions of that act, came to the conclusion that it does not contain any provision which creates a bar in regard to the entertainment of the suit which has been filed by the plaintiffs, who are claiming only right to worship the idols and deities existing within the premises of the temple. Uh, and the fourth defendant has therefore failed to prove that the plaintiff's suit is barred by the UP Shri Vishwanath Temple Act, 1983. Consequently, the only consequence which can ensue on these findings is that the application for rejection of the plaint under Order 7, Rule 11, filed by the management of the mosque, has to be dismissed.
You can explain so what is the result of the case?
So the result is that the application under Order 7, Rule 11 has been dismissed. But every litigant who goes to the court, either as a plaintiff or a defendant, has got to have a stout heart. So two options are now available. One is that to go ahead with the trial of the suit, but if they if the fourth defendant wants to prolong the proceedings, well, he can go to the High Court to get the order of the learned district judge revised under Section 115 of the Code of Civil Procedure. Or he can also invoke Article 227 of the Constitution. So those two options are available to him. So uh, you will recall that Supreme Court itself has directed in its order of 20th May 2022 that the interim directions given in that order will remain in force for 2 weeks after the order is passed by the district judge. So that means that, the court itself provided them time to enable them to seek their remedies in the High Court. So they can, the Intizamiya committee can go to the High Court, as I said, in revision under Section 115 of the Code of Civil Procedure, or by invoking Article 227. So the time given by the Supreme Court in its order dated 20th May 2022 will enable them to avail this remedy, at ease. 2 weeks' time is enough to prepare the grounds of revision and file it and have it listed. So they can avail that remedy and go to the High Court. Needless to say that Article 136 has been applied so widely that, no one will say that no, from an order passed in revision under Section 115 of the Code of Civil Procedure, you can't come to Supreme Court. So that's it.
Yes, I hope we will see next what will the mosque will do and will go to the High Court and what is the judgment of it. Thank you, sir, for informing all about it, and that's all for the day, sir. See you, sir, in the next
Thank you,
video.
Krishna.
Thank you, sir.